All right, good morning and welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call the docket this morning. When I call your name, please say present or here. Maybe. Test. Yes. Yeah, I got it. Test. Better. All right, when I call your name, please say present or here. And counsel, I'd like an announcement whether we're going to be having an evidentiary hearing or a contested hearing today, or if it's going to be a plea. Michelle Daly. Ms. Abraham, are you in the jail court?
Yes, Your Honor.
Does this docket tell me if they're in jail or not?
Yes, sir.
Where does it tell me that? Do you know? I'm going to show you. I don't see anybody that's in jail.
The bottom of page 1 is Josh Martin, and it should have it highlighted in jail.
We've only got these that you put on this spreadsheet right here. Everybody else should be out of custody. These are the only ones in
Yes,
jail.
sir.
Okay, cool.
Yes, sir.
Michelle Lynn Daly. Jacob Frericks. Oman Pazlara. Oman Jesus Pazlara. Nathaniel Whiteley. Kevin Lee Wood. Kevin Lee Wood. He's what? Dimitri Worsham. Donald Ellis is in custody. Landon Watson. Julian Bahina. Caleb Richardson.
Last contact I had with his family, he was in a coma in a hospital, reading about a car. I had not had any further contact with him, so I think we'll arrange for having him here today.
When was the last time you talked with his family?
That was shortly after our bond setting on the PR bond back in April
Of this year?
Yes.
Kobe Heron. Dakota Pfeiffer. Christian Dickinson. Not here. Johnny Harris. Colin Teague. Colin Gary Teague. Christopher Hundley. I believe Mr. Hundley is appearing via Zoom, and he is present in the online waiting room. Mario Gutierrez. Think so. Heron, Burton. Mr. Green here. Do we know, State, if we're having a hearing on?
We still don't have a motion. Last setting, we give,
Go ahead and tell me.
Judge, last setting was set for motion to suppress, state called response and proper grounds. We received no further motion. I believe Mr. Green was requesting additional date.
All right, I'll recall that one.
That's correct.
Morning. All right, Miss Tabraham, you said that you have Mr. Ellis.
They're coming in the door now.
Okay. All right, court call CR 19305, State versus Donald Brian Ellis. Go ahead, Ms. Beasley.
Yes, sir. We're before the court this morning on a motion to quash the defendant's indictment. It's our argument that it is fundamentally and fatally defective because it does not include the words without consent. According to Gonzalez states, 337 Southwest 3rd, around page 481, says without consent is an essential element in both sexual assault cases and aggravated sexual assault cases. And therefore, the defense would ask that the indictment be quashed and that the state be barred from filing any new prosecution charges and that this case be dismissed with prejudice, Your Honor.
State.
Correct. If I may, in addition, Your Honor, the original indictment was initially amended back in February of 2020. So my client has spent almost 2 years in jail on fundamentally defective indictment.
Hang on, is that all, Ms. Beasley?
Yes, Your Honor.
All right, Ms. Heisel.
Judge, this is a matter handled by Ms. Flurry. It's my understanding that she is on her way to make the state's announcement on this. And we just ask this to be recalled.
Okay. All right, just have a seat, Mr. Ellis, and we'll recall you. Do we have anyone that's agreed this morning?
I didn't hear what she said.
You ready to go now? Anyone that's agreed and ready? If you'll come over here to the left so I can line y'all up and I'll know who's up. Mr. White, Nolan White.
Your Honor,
Yes, ma'am.
we didn't hear what Ms. Heisel said.
Ms. Heisel said that Ms. Curry is handling the case and she wants it recalled so Ms. Curry can get here to make an announcement.
Okay.
All right, court call CR 2344, State versus Christopher Lamar Hundley. And Mr. Hundley is being brought in on Zoom. Let's give him a second to connect. All right, Mr. Hundley, just raise your hand if you can see and hear me this morning. All right, record will reflect that Mr. Hundley can see and hear the court. Go ahead, Mr. White.
Your Honor, today Mr. Hundley was set for motion to suppress. We filed a motion to withdraw. That motion to suppress, we asked the court to reset this for a plea.
All right, has the court already set this for a plea?
I do not
On a date.
believe so, Your Honor.
Is there a certain amount of time you're requesting?
I believe you got it in July. In July, that's not too.
I've got July 13th, 15th, 27th.
We do the 27th, Your Honor.
You trying to get my attention? Are you trying to get my attention?
No.
Oh. All right, court will set Mr. Hundley to appear in court for plea on July 27th at 9 a.m. Mr. Hundley, this will be the only notice that you receive from the court, July 27th at 9 a.m. Do you understand?
Yes, sir. Can you hear me?
Yes, I can hear you. Okay, July 27th, 9 a.m. You're free to go.
All right. Thank you, sir.
Is that all you have, Mr. Wells? Mr. White, who do you have? I don't see you on the docket.
June, Bahina, to adjudicate, state 953, to reset this. I believe we have pretty much got an agreement in principle. We have this.
CR 18456, State versus Julian Bahina. Mr. Bahina here. Mr. Bahina, if you'll come up to the podium, please.
And we also will be getting
You'll be getting an amended MTA on what grounds? I couldn't hear you.
I've just been informed that you're going to have amended MTA coming.
Judge State just signed that this morning for filing, so obviously we will need a reset to get a copy of that to Mr. White, to notify him of the new allegations and whether or not that would change our agreement.
Sir, new alleged offense?
Judge, I signed a bunch this morning off the top of my head, I don't remember what the amended.
Do you remember, Mr. White? Or do you know?
I'm specific.
Judge, there are two allegations. One is consuming alcohol and one is consuming marijuana.
I know those allegations alleged to have occurred while Mr. Bean has been on bail in this court pending a motion to revoke hearing.
Yes, Your Honor.
Mr. Bahina, have a seat. We're going to recall your case in a minute. I'm going to decide whether or not you're going to jail today. Don't leave the courtroom, Mr. Bahina. All right, Mr. Manning, are you ready?
Yes, Judge. Mr. Richardson.
Court call CR 21-141, State versus Caleb Reed Richardson, set for arraignment today. Mr. Manning has stated that, go ahead and state for the record again.
Yes, Judge. I received information. I checked my email back on March 30th that Mr. Richardson had been hit by a car and was in the hospital. At that time, he was in a coma and unresponsive. I requested medical record, police reports, that type of thing, but I have not received those. I've been in contact with his mother since that point in time.
State, do you have any additional information on Mr. Richardson?
Judge, I've just been made aware that Mr. Manning has presented the state pictures of his hospitalization, even though we don't have records. We have no further information beyond what Mr. Lee was given. We're opposed to that.
All right, we'll reset this for arraignment and status.
And if I'm able to get on it, I will get a waiver arraignment.
Let's reset. I know it's only 30 days, but that way we'll get a status update on July 27th. You available?
Yes, I am, Judge.
All right, we'll do July 27th, 9 a.m. Is that all you have?
Judge, I would also have an individual in jail time, Joshua Perez. I received an offer from the state this morning, get a motion for both. I haven't been able to discuss that offer with them. I don't know if the jail would permit me to go out there today and discuss it with them, but.
Morning, Judge.
Hang on, Mr. Platt, I'm in a hearing. Go ahead, Mr. Manning.
They wouldn't be opposed to a reset. We can get that offer and see if we have an agreement on that.
That's the state's understanding, Mr. Manning. I believe he has some discovery, but we might have to discuss before the May setting.
All right, we need to wait and get Mr. Perez in here so that he can hear all of this. So, okay, I'll recall the case whenever.
He's on his way up.
Okay, that's fine. Just let me know when he gets there and I'll
Okay.
bring Mr. Manning back up.
And then I have Josh Martin when you're ready for him.
I think this says Joshua Winters. That might be the wrong court. Give that one back. This is Judge Winters. I don't know. Mr. Knoll, are you ready on? See, so the ones that you're pleading today are inmates, is that correct? Backus and Phillips.
That's correct, Your Honor. That was the part that we're banking.
Are you ready on Dakota Piper?
Exactly. I am ready for whatever reason. I don't have an answer. Judge presiding at the winner office is not correct in this case. It's always.
Okay, I'll let you talk with the state about that. You can get back to me. Anyone else who's ready? Ms. Dickinson? CR 13-6, State versus Christian Rochelle Dickinson. Yes, ma'am. Let's let Ms. Dickinson get to the podium so she can be involved in hearing. It's okay. Right here at the podium. All right, go ahead, Ms. Fox.
Yes, Your Honor. I would like to draw on this case. I was in trial last week, so I didn't get a chance to file a motion. And Ms. Peterson has informed me she would like to hire an attorney. We are having a major conflict.
Well, I'm not going to take up the motion to withdraw without it being filed and given to the state for notice.
I'm willing to, I guess. So just we have to reset so we can file. So we got to communication.
Any other announcement from the state on Ms. Dickinson's case?
Judge, I came into today with the understanding that we all have an agreement to move forward with a resolution to this case. However, I did email Mr. Crawford yesterday and let him know that that wasn't signed yet. So the state's prepared either way to go forward today. We tried contacting Ms. Fox, but because of her communication with her client, didn't get an answer back. So states here, whatever the court decides we need to do today.
What was the proposed resolution?
It was for TBC time function.
To be effective today, to go into custody today?
That was our understanding.
And who's Mr. Crawford?
Jarvis Crawford. He's the
Okay.
probation,
I didn't know if you were talking, I didn't know if you were talking about Mr. Michael Crawford, potentially another defense attorney that Mrs. Christensen may be wanting.
If we receive the court decide we need to proceed with hearing, the state would be ready to do that today.
All right, Ms. Christensen, have a seat. I'm going to recall your case in just a moment. No, you may not. You can sit down though.
Your Honor, we have Mr. Perez.
You have Mr. Perez? All right, I'll call him in just a minute. Mr. Manning, you ready? Court call CR 19-272, State versus Joshua David Perez. All right, Mr. Perez. Mr. Perez, can you see and hear me okay?
Which one are you? The left one right here?
Say again?
Yes, sir. Yes, sir.
Okay. All right, go ahead, Mr. Manning.
Judge, we received an offer on Mr. Perez today. I haven't had an opportunity to convey that to him. I'd like to go to jail today, convey it to him, a request for reset, in order for us to make an offer and seek a resolution.
What's the offer?
I believe I understand the offer was basically a time served offer on revocation. Right.
Judge, I think we're gonna add a week or two, not a substantial amount of time.
You want me to move this case to the afternoon and recall it this afternoon and give you time this morning to speak with him?
The only question is if I'd be able to speak to him in jail according to the new policy.
I think you should probably have an hour before they restrict that.
Okay, then I'll head right out there. Say the reset.
Yeah, save that reset, and then are you available this afternoon? Okay, I'll recall it then at 1:30.
They'll recall you at 1:30.
Today? Okay, you want to-
All right, if we can bring Mr. Ellis back up, Ms. Beasley. Ms. Curry, are you ready on Mr. Ellis? I'm going to have him brought back up.
Sorry, Your Honor, I failed to let Ms. Idle know that I was busy with her lawyer.
That's okay. It's okay. Back on the record, CR 19-305, State versus Donald Brian Ellis. And Ms. Beasley had stated to the court her position on her motion to quash the indictment. And Ms. Heisel indicated that you were handling the case and asked for the case to be recalled.
Yes, Judge. Can I ask what Ms. Beasley's position was?
Ms. Beasley, would you indulge the court, Ms. Curry, again with your argument?
Yes, sir. The indictment in this case is fundamentally and fatally defective. It fails to allege the words without consent. According to Gonzalez v. State, 337 Southwest 3rd, 481, it states that without consent is an essential element of both sexual assault and aggravated sexual assault cases, and that's not included in the indictment. This indictment originally was amended back in February of last year. It still is currently fundamentally defective because it does not include those words. And because of that, we'd ask for a dismissal with prejudice. It states in Studer v. State, 799 Southwest 2nd, 263, That case holds that a defect is a failure to allege an element of an offense in a charging instrument, and that court also held that the terms substantive or substance defect, fundamental error, and fatally defective are interchangeable terms. And because this indictment is fatally defective, it does not invest this court with jurisdiction, and as such should be dismissed with prejudice. In addition, King v. State, 600 Southwest 2nd, 288, holds that everything should be stated in indictment which is necessary to be proved. The indictment does not give adequate notice to Mr. Ellis of the charge against him, and therefore should be barred to subsequent prosecution for the same offense. We'd ask that the case be, indictment be dismissed with prejudice, Your Honor.
Thank you for doing that, Ms. Beasley.
You're welcome.
Thank you, Your Honor. Two things, Your Honor. If the court believes that the indictment is defective, I do not believe the court has the authority to dismiss a cause at this point of the proceeding with prejudice. Secondly, I would assert that the facts of this case will show, and the indictment alleges, that the victim in this case is a disabled individual, mentally disabled individual who is incapable of giving consent. I understand Ms. Beasley's position. I understand the case law that she is citing. I do not know off the top of my head if that is factually similar to cases where the victim is incapable of giving consent or not. I certainly could research that and determine. We would ask, Judge, that the court take Ms. Beasley's motion under advisement. Allow me time to review that case law.
Ms. Beasley, any response?
Your Honor, we would strenuously object for the state to have any more time. That my client's been in jail, in custody, held without his ability to be in the free world, and ask that the court grant that motion as soon as possible.
And to that, I would say that in this case, her client has also been, part of the reason that he is still in jail is that he has been trying to make a decision as to whether or not he wants additional DNA testing. If his decision had been no, we could be on the trial docket. If his decision is yes, then of course it is going to continue to pend for a period of time.
All right, court's going to take the motion to quash under advisement, and we'll give Ms. Curry time to respond. How much time do you need? How much time do you request?
30 days. Sir.
All right, court will reset Mr. Ellis to the evidentiary docket on July 29th.
Thank you.
At what time, Judge, since he's in custody?
I usually set them at 9 on the evidentiary days.
Can we set his at 1:30, Judge, since we know he's in custody?
Well, that depends. Are you requesting it so because he's in custody, or because you think it'd be better for you at 1:30? Because on these days, I typically don't set all my inmates at 1:30, because if there's 20 evidentiary hearings, I can't start 20 evidentiary hearings at 1:30. So I start everybody at 9, like today, and then see who's going to plea, who's going to have an evidentiary hearing.
Well, we know this is going to be an evidentiary hearing on the motion to quash or get a ruling from the court. I'll do whatever the court wants. I can be here at 9. It just gets confusing sometimes about where we need to be on evidentiary day.
I understand. Well, evidentiary day is always at 9 a.m. The only time it goes to 1:30 is when counsel requests cases to be moved to 1:30, which I try to oblige counsel in doing that. It's not my intention to be confusing on anyone. It's my intention to help everyone out. So we'll set it at 9 a.m. on July 29th.
Yes, sir.
Ms. Tabram.
Yes, Your Honor.
Is there an order of inmates that we're bringing up in the jail? Just so I
We
know.
have We have Joshua Martin, we have Sotelo, Evans, and Montgomery on their way. And that will just leave Larry Watson.
Are they coming in one by one, or are we bringing them in as a group?
We're bringing these next three in as a group.
And so that's going to be Sotelo.
Sean Evans and Bobby Montgomery.
Okay.
Judge, if I may, two of those three. We want to make- go to jail to have that. You know what I mean?
Okay. All right. All right, let's do that one.
Judge, you just stepped out of the bathroom, so grass.
Who is that, Mr. Schmidt?
He's retaining me, I'm not sure. I thought I found notice of appearance. And we're gonna ask to reset him this morning.
Go ahead and grab him, and then I'm gonna move on real quick, but as soon as you grab him, let me know. All right, CR 2324, Karen Sue Burton.
This morning, we're able to reach a resolution in the case that does not need an evidentiary hearing. Just need to set it for a plea date.
All right, so defense is withdrawing any formal motions to suppress or evidentiary requests.
That's correct.
All right, court will set Ms. Burton then for a plea. Got 3 dates available, July 13th, 15th, 18th,
Let's do 13th. 10 o'clock.
9 o'clock. Is Ms. Burton going into custody?
It's a time served plea.
Time served, so she won't need to go into custody
That's
at all?
correct.
Okay, so 9 o'clock. Yeah, if she's already signed it, you can just lay it right there on that one. All right, Ms. Burton, we'll see you back on July 13th at 9 a.m. Yes, thank you, Mr. Green. Rachel. Rachel.
Got one more thing to say. Okay, we'll get-
Your Honor.
Yes, ma'am.
Have Montgomery and Evans.
Okay, I'll call him in just a few minutes. All right, Ms. Fox, Ms. Dickinson. You may. All right, Ms. Dickinson, I'm going to order you to undergo a drug test at this time. So come over here and have a seat. and Officer Matura will be with you in just a moment.
Your Honor, she's agreed to offer to send it for
She's gonna take the plea today.
being
This is a quick 180 from she doesn't want you as a lawyer and she doesn't want the plea to now she wants you as a lawyer and she wants the plea. Have you counseled her and have you had enough time to talk with her about this to make sure that this is what she wants to do and that it's intentional, knowing, and voluntary? Do we have the paperwork? Okay. All right, have a seat and we'll recall you in a moment. Thank you, Ms. Fox. Yes, I was actually calling you up next. Mario Gutierrez. Mr., I'm trying to recollect, you have one client that needs an interpreter, but this is not Mr. Gutierrez, is that correct?
You need an interpreter? Just what we're asking is, we haven't got discovery for the indictment. I'm about to go pick it up right now. I asked if the case be reset for a time that we can reset.
Well, I think what I'd rather do is I'll just print out the indictment and give it to you. Let's just affix his identity, make sure he knows what he's charged with, name is spelled correctly. We'll enter his plea of not guilty. And then typically what I do, Mr. McCasley, is I go to arraignment, then I'll set it for pretrial so that you can get that discovery, file any contested pretrial motion you want. So let me print that out for you and I'll have one of my staff members bring it to you. Okay. So Mr. Gutierrez, have just a seat for just a moment and I'll call you back briefly. Ms. Barker, if you can assist the court, I need the indictment in CR 21119, Mario Gutierrez. If you can print that out and bring that to Mr. McHaslett, he's sitting near the TV on the bench in the courtroom. If you can just send me a message that you've heard that, I'd appreciate it. Mr. Schmidt, are you ready? Mr. Whiteley. Nathaniel Dean Whiteley, CR 1934. All right, Mr. Whiteley said on his motion to revoke today, Mr. Schmidt.
Judge, as I made the court aware of everything on this way, spoken inside of it. We're gonna engage in some additional discussions on this, like this case, we have to come out of this.
Any objection from the state?
No, Your Honor, stage you, Mr. Wiley, was in discussion with Mr. Schmidt, however, we didn't know he had been. We weren't prepared to go for it.
All right, court will reset Mr. Whiteley to the evidentiary docket on July 29th at 9 a.m. And Mr. Whiteley, before you leave today, you need to report to probation over here, okay? So get your notice of setting, come on around and see the officers, and they'll instruct you further. Yes. Ms. Abraham, I want to inform you that Mr. Schmidt is on his way over to the jail court to speak with his clients, Evans and Montgomery.
Hey.
Mr. Knoll, are you ready? Piper? Hitting everything? Dakota Piper, CR 2266. All right, Mr. Piper, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Piper, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Sometimes it gets loud in here. If you'll just speak up loudly and clearly for my court reporter here, okay? Mr. Piper, is your name Dakota Anthony Piper?
Yes.
Am I saying that correctly? Mr. Piper, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you?
Yes.
Do you feel like you've had enough time to discuss your case with him, have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand? Mr. Knoll, do you believe Mr. Piper to be competent today?
Hey,
You've explained to him his legal and constitutional rights.
I have.
I see here that the recommendation is upon a plea of guilty to a lesser included offense of evading arrest or detention. The state recommends that punishment be assessed on the Class A misdemeanor at 225 days in the county jail, with Mr. Piper receiving credit for time served, with assessment of court costs of $270 and reimbursement fees of $20. Is that correct, Mr. Knoll? Is Mr. Piper going to be paying his court costs and reimbursement fee today? All right, Mr. Piper, you were originally charged, let's see here, with evading arrest or detention with a vehicle, a third-degree felony. However, with the plea agreement being to a lesser included offense of evading arrest or detention, that's a Class A misdemeanor, which carries a range of punishment of confinement in the county jail, not to exceed 365 days or a $4,000 fine. You understand that range of punishment? And I see here that the proposed plea would legally fit within that range of punishment. Understanding the plea agreement and the range of punishment, how do you plead to the Class A misdemeanor of evading arrest or detention?
Yes.
Mr. Piper, are you pleading guilty to that charge because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Nolan, any objection to States 1?
No, Your Honor.
States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Take a moment to review that evidence. Mr. Knoll and Mr. Woodward, will you approach? We'll be off the record. All right, we're going back on the record, CR 2266. All right, court has reviewed the evidence, Mr. Pfeiffer. I'm going to find that there is sufficient evidence to convict you of this offense. The court is going to follow the plea agreement in this case. Court convicts you of the Class A misdemeanor offense of evading arrest or detention. Court assesses your punishment at 225 days confinement in the county jail. Court awards you 255 days credit towards your incarceration for time spent on this case. Court orders you to pay court costs of $270 and $20 reimbursement fee. And if you're not able to pay that today, Mr. Pfeiffer, then I order you to report to the court's collection officer at the end of the hall to set up a payment plan before you leave today. All right, Mr. Piper, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted. After you're fingerprinted, then step down to the collection officer at the end of the hall and set up that payment plan. Thanks, sir. So, Mr. Knoll, your clients, Backus and Melton, or I'm sorry, Backus and Phillips are this afternoon, correct? Okay, well, I see they're on the afternoon docket, so they probably weren't planned to be pulled this morning, so. Do you have anything else this morning? Anyone that's on bail? Let me see if is Mr. Watson. Is Mr. Watson in the jail? I mean, is he available in the jail?
No, sir, we've not brought him up.
Okay, I'll recall this case. Mr. Schmidt, are you ready?
Yes, sir.
Who are you ready on?
I'm ready on both. We can start with Mr. Evans.
All right, CR 1914, State versus Sean Evans. Go ahead, Mr. Schmidt.
Judge, we were here on the state's motion to adjudicate Mr. Evans' case. We've been able to reach an agreement with the state, and that would include reinstating Mr. Evans. He would be placed on intensive supervision program as well as a couple of other amended conditions. I've gone over those amended conditions with Mr. Evans. He understands them and has signed them. I have that in my hand now. And we would ask the judge to approve that agreement. I think I provided the court with a copy of the state's motion to withdraw their MTA and continue Mr. Evans on community supervision.
The state's motion with the amended conditions of probation, so I believe they will be in jail.
And Mr. Schmidt, yeah, you left the motion to withdraw. I have that, but do you have the conditions with you? Okay.
Yes, sir. Mr. Evans has gone over them with me and he signed them.
Okay. All right. The court will grant the state's motion to withdraw the motion to revoke and sign that order this day. And Mr. Schmidt, if you'll just leave that with Ms. Taberham, the paperwork, and she'll bring my signature.
Sir.
All right, Mr. Evans, let's make sure that this is the last time that you end up in custody before the court regarding your community supervision. You understand?
Yes, sir.
All right. All right. We're through in this case. CR 1428, Say versus Bobby Ray Montgomery. Mr. Montgomery set today on motion to revoke.
Yes, Judge. We received a offer from the state this morning, and I've conveyed that to my client here a minute ago. As you recall or may not recall, I was appointed on the last docket day right prior to me leaving the state for vacation. So I haven't had a lot of time to discuss the motion with Mr. Montgomery. I discussed it with the state. We're going to ask for an additional setting on this case for the actual motion to revoke. And I think the state's in agreement with that. In addition, I filed this morning a motion to reduce Mr. Montgomery's bond. I think the state is aware of it, but we're ready to proceed on that if the state has no objection.
You said you filed it this morning?
Yes, sir.
State.
Judge, we got notice on that, however, I'm not going to take that up this time.
All right, go ahead, Mr. Schmidt.
Judge, I would call up Mr. Montgomery for the purposes of a bond reduction hearing.
Mr. Montgomery, if you'll raise your right hand. Mr. Montgomery, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, go ahead, Mr. Schmidt. You put your hand down.
State your name for the record, sir.
Ray Montgomery Jr.
And you are currently incarcerated in Van Zandt County Jail on the state's motion to adjudicate your community supervision, correct?
Yes, sir.
And how long have you been in custody on that motion to adjudicate?
42 days, I believe.
And right now your bail is currently set at $20,000, is that correct?
Yes, sir.
And are you able through yourself or through family to post the $20,000 bail?
No, sir.
And is there an amount that you think you or your family could come up with that would allow you to be out of jail pending the resolution of this case?
Trying to get a PR bond.
A PR bond? You're asking the court for a personal recognizance bond?
Yes, sir.
So there, right now, there's no dollar amount that you think that you have substantial enough property
I
or?
don't know if my family could do 5,000 or not.
Okay.
And Mr. Schmidt, I can barely hear him. I don't know if it's
Sorry.
audio or he's just not speaking up, but if he wants to be heard, he's going to have to try a little harder.
So I'm trying to get a PR bond, but I'm not sure my family can afford, maybe 5,000. I don't know.
So in any event,
My behalf is a PR. That's all I can afford.
so at this time, you're asking the court to reduce your bond to a personal recognizance bond, but you are asking the court reduce it in the hopes also that perhaps if he doesn't grant a PR bond, that maybe your family can help you bond out, correct?
Yes, sir.
And if you were to make bond pending the resolution of this case, do you have a place to live?
Yes, my father.
And do you have transportation back and forth from court?
Yes, my father.
And are you assuring the court that if you were to make bond on this case, that you would be present for all your court hearings as set?
Yes, sir. Yes, Your Honor.
I'll pass the witness, Judge.
Faisal, no questions. Any further evidence, Mr. Schmidt?
No, Judge.
Just argument?
Judge, I'll just, I'd rest on the motion and ask the court to allow Mr. Montgomery to make a PR bond pending resolution for this case. I would note for the court that it is a 2014 case. I know that Mr. Montgomery's been on community supervision for quite a while. In the motion, there are no, let me double check. Only at the very recent time when there was some issues with family, is there any allegations that he failed to report? So by and large, he's been reporting as ordered. minus a couple of glitches. So we'd ask that he be allowed to post a PR bond.
Thank you, Mr. Schmidt. Ms. Heisel.
Your Honor, the state would just ask you to take judicial notice of the state's motion to adjudicate on file, and notice that Mr. Montgomery had 5 instances of illegal substance use in 6 months, based on his recent track record with specifically marijuana. We would ask that his bond remain until the case is resolved.
And I see bail is currently set at 20,000. Is that correct?
Correct, Judge.
All right, court's going to deny the defendant's motion for personal recognizance bond or a personal bond. And the court's going to maintain bail in this case at $20,000.
Thank you. And we need a reset date for the MTA.
We'll set Mr. Montgomery on July 29th for a contested hearing.
That's all I have, Judge. May I be excused?
Yes, thank you, Mr. Schmidt. Mr. Bingham, are you ready on Dimitri Worsham? Dimitri Worsham, CR 2197. Is that a plea today? Mr. Worsham, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Yeah. Are you Dimitri James Worsham? Mr. Worsham, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Matt Bingham. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand? I see that the defendant hasn't been sworn. Mr. Worsham, where your signature appears throughout these documents, is this your true and correct signature? And did you only sign after you understood what you were reading? Mr. Bingham, do you believe Mr. Worsham to be competent today?
He is competent, Judge.
And you've explained to him his legal rights, and have you also explained to him the advantages and disadvantages of a deferred adjudication plea?
We have met with Mr. Worsham more than one occasion. We've gone through the plea papers, talked about what rights he enjoys as someone accused of crime and the pluses and the minuses.
And you believe he understands it?
He does.
All right, Mr. Worsham, you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 2 greater than or equal to 4 grams, but less than 400 grams. Mr. Worsham, a second-degree felony carries a range of punishment of confinement in the Texas Department of Criminal Justice for a period not less than 2 years or more than 20 years, and an optional fine not to exceed $10,000. Do you understand that full range of punishment? What that means, Mr. Worsham, is if I approve this recommendation from the state to defer a finding of guilt and place you on community supervision for 3 years with fine, restitution, court costs, and those things, if I approve that and place you on community supervision. If during that term you violate any of the conditions of your community supervision and the state files a motion and they bring you back to court and they prove that to the court, then the court could be in the position of revoking your community supervision, convicting you of this second-degree felony offense, and assessing your punishment anywhere between 2 years and 20 years. You understand that? Understanding that, you still want to go forward with this plea. All right, Mr. Worsham, then how do you plead to the second-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 400 grams? Mr. Worsham, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty? All right, court accepts the defendant's plea of guilt. Mr. Mingum, any objection to states 1?
We have no objections, Mark.
States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
We do, Judge, as part of this 3-year deferred recommendation, $500,000 restitution, they had agreed graciously to 1245 consider a possession of marijuana, two possession of marijuanas that are outlined in the terms of the agreement on the first page. Mr. Worsham would acknowledge his guilt in both those cases and ask the court to consider us assess the punishment in this case with restitution. If they were tested, we have to pay that back as well.
Thank you, Mr. Bingham. All right, Mr. Worsham, based on the court's review of the evidence, I do find there's enough evidence to convict you of this offense. However, the court will follow the plea agreement in this case. The court defers the finding of guilt, places you on community supervision for 3 years, orders you to pay a $1,000 fine, $180 restitution. Court finds that DA 2020-342 and M19-363, both possessions of marijuana, will be considered and taken into consideration under section 1245 of the Texas Penal Code. Court also orders you to pay a $35 reimbursement fee. All right, Mr. Worsham, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the deputy, and then I want you to report to the probation department over here to my right and your left. Thanks, sir. I'm going to recall you in just a moment on Mr. Martin. Mr. Adams, are you ready? Is Mr. Wood here? He's not. Is that all you have this morning, Mr. Adams? He's also Just for whatever reason, the things are not in alphabetical order. Well, I see that. CR 21-191, State versus Colin Gary Teague. Is Mr. Teague here? Johnny Ray Harris, CR 15-24. Harris here. All right, Mr. Harris, if you'll raise your right hand, sir. Mr. Harris, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. You are Johnny Ray Harris Jr., is that correct? Mr. Harris, are you a United States citizen? You read, write, and speak English. Mr. Harris, you were placed on community supervision by this court. Back here to it. Back on September 28th of 2017. You pled guilty to a third-degree felony offense of assault of a family or household member with previous conviction. The court heard the evidence on that day, found that there was enough evidence to convict you of the offense, but the court followed a plea agreement and deferred a finding of guilt in your case and placed you on community supervision for 8 years and assessed a $2,500 fine. It was during that term of your community supervision that the state of Texas filed a motion to adjudicate your guilt and revoke your community supervision on March 8th of 2021. Have you had enough time to review that motion with your attorney, Mr. Mitch Adams? Feel like you've had enough time to meet with him regarding this motion, have all your legal questions answered? Is there anything about this paperwork that you've read and signed today that you do not understand? And are you pleased with Mr. Adams' representation of you? Mr. Adams, do you believe Mr. Harris to be competent today? Does he waive the formal reading of the state's motion to adjudicate? I see here that the proposed plea agreement is that Mr. Harris is going to plead true to the state's motion to all counts. And the recommendation is that guilt be adjudicated, that his community supervision be revoked, and that he be sentenced to 5 years in TDC with a balance of financial obligations.
That's correct, Your Honor.
That's your understanding, Mr. Harris? All right, Mr. Harris, then I'm going to ask you with regards to counts. I'm reading from the state's motion to adjudicate with regards to count 1, 2, 3, 4, 5, 6, 7, 8. Are those counts alleged? Are those counts true or not true, Mr. Harris? And are you telling me that those are true because in fact they are true and you are guilty of committing those violations? Has anyone threatened or forced you to plead true today? Say again.
No, sir.
All right, court will accept Mr. Harris's plea of true at this time. Mr. Adams, any objection to the admission of the defendant's waiver of rights and defendant's plea of true as states exhibit A?
No objection, Your Honor.
States A is admitted in evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? Anything at some point, is there going to be something?
Two things, Your Honor.
Go ahead.
The court can't do that. Has to take a close look at. You will see allegations of that Mr. Harris has a problem. We just asked the court to make a finding that needs treatment and rehabilitation to address that issue, so that whatever program is available for him, TDC facility, maybe help put him first in line or close to the front of the line to receive that treatment while he's waiting, rather than having to wait without the finding for him to get into the program. The second issue is Mr. Harris has informed me that he he would like to report the county on Friday. My fact, this week, he has some errors put in where, which that is personal little documents. So I would pass that question on the court. I would ask for it's not
And how would to address issue one, the finding, is that a finding that is proposed in a written order that I can sign that will go with the paperwork to Mr. Harris? Otherwise, they're not going to get it off the transcript and they're not going to watch my YouTube channel.
You're right. It's not the same file. So what I can do is I can file a request for that finding. Well, I guess those probably
I think we could just call it finding by the court and it will go down with his plea papers. They will review the judgment and the motion and stipulation. All of those things go down as part of the pen pack. And so I'm happy to make the finding. I just want to make sure that it follows Mr. Harris, because if I announce it on the record, it's not going to go to TDCJ and it doesn't do him any benefit. So, but the court will make the finding as requested by the defense that alcohol or drugs has played a significant part in Mr. Harris's adjudication today. With regard to request number 2, unfortunately, the court's going to deny that request, Mr. Harris, and the court's going to order you into custody today. All right, so Mr. Harris, I'm going to have you come forward to be fingerprinted with the deputy, and the deputy, if you'll take Mr. Harris into custody. Mr. McCaslett, is that all you have? Okay. And so I've already called their name, so over and out. Over and out. If they show up, I'll make sure that they are put away safely for you. Yes. Hang on.
No, it's nothing. Mr. Catch.
Mr. McCaslett, are you ready? Appreciate your patience, sir. Mr. Gutierrez. All right, CR 21-119 set for arraignment. Mr. Gaslett, have you had an opportunity to review the indictment with your client?
I have not.
And is his name spelled correctly?
Yes, it is.
Does he waive the formal reading of the indictment? And does he understand what he's charged with?
Yes, he does not.
And does he enter a plea of guilty or not guilty?
Not guilty.
All right, court will enter Mr. Gutierrez's plea of not guilty into the record. And we'll set Mr. Gutierrez then for a pretrial hearing. You have your calendar available, Mr. McCaslett? Let's see, understanding there's probably going to be some video evidence in here you're going to have to get and review. You said you're working on getting that today.
Yes, Your Honor.
Let's see, what about August 10th or 12th? Is one of those better than the other?
August 10th.
Okay, we'll set Mr. Gutierrez in for pretrial on August 10th. And we'll just remind counsel that according to the code, all pretrial matters must be filed 7 days prior to that date. So what I'll do on that pretrial date, Mr. Gutierrez, is if there's a request on a motion to suppress or a motion to quash, something of that nature, we'll file it on that day. You'll file it 7 days prior to that. And then on the pretrial date, we'll take up any other issues if you're having difficulty getting a discovery, or if there's any other issues you need to bring to the court's attention. But on that pretrial date, we won't be arguing the contested information. If it's quash or suppression on that pretrial date, it's kind of a deadline update for the court. And then if there's an evidentiary hearing requested, then we'll set that for later in August.
Thank you, Judge. What time would that be?
It'll be at 9 a.m., 9 a.m. as long as Mr. Gutierrez is on bail. And it'll be at 1:30 if he's in custody for any reason. Yes, once he signs that notice of setting and then, here you go. He gets the yellow one and then, oh, you already got it? Okay. Already signed it. Here, if you'll put those dates down there, right here. And then check off pretrial on the left side. Oh, yes, he does. And so, Mr. Gutierrez, once you get this yellow copy, I want you to come over here and meet with pretrial release, okay? There you go, thanks, sir. Yeah, he gets the yellow one and then he's gonna come over here and meet with pretrial release. Fox, just let me know when you get the paperwork ready. Don't be shy. Shy people come back at 1:30. Nice side here.
Judge, I've got a parole hearing I got to get to.
Is it your parole hearing?
Not this time.
Not this time. I'm ready for you, Mr. Platten. Landon.
Okay.
Landon Watson, you come forward, sir. CR 18-113. Mr. Watson set on motion to revoke. Go ahead, Mr. Platten.
Yes, Your Honor. I filed a motion for continuance in this cause. The state provided some discovery to me in this DWI case, which spurred on his revocation in this case before the court. I've received some paper information, but I need to get the video in that. And I haven't obtained it just yet. For those reasons, I'd ask the court to reset this for another status.
Any objection from the state?
Judge, we began making that copy and I think.
Will you turn your microphone on because I'm not sure he can hear you.
You hear me, Mr. Platten?
I can a little.
Judge, we started making that. We would not be opposed to resetting the motion to vote. I believe we will also file a driver intoxicated in this court. So we can
Okay. But there's it's my understanding there's an unfiled DWI at this time.
We have received paper discovery, which is Platten, but not video discovery. I do believe Mr. Platten.
Is that a misdemeanor or a felony allegation? Misdemeanor. Okay. All right. So we'll set Mr. Watson then on July 29th. That's the next contested docket date.
So it's set for contested hearing now?
On the motion to revoke. This is a motion to revoke. So we go from contested docket to contested docket.
Okay. Does the state know if blood alcohol concentrations available?
No. Do you know what the alcohol concentration is?
Judge, I believe we're still waiting on there was a breath test that failed, and then Mr. Watson consented to a blood test. I don't believe we'll request the date.
Okay. So we'll just come back and if we don't have that evidence available on the 29th, Mr. Platten, then we'll continue until we get it.
Okay. Thank you, Your Honor.
Okay. So Mr. Watson, I'm going to have you sign this notice of setting. All right, Mr. Watson, I'm going to have you sign here on the X, and then we're going to give you a yellow copy, and it's going to show your reset date to 7/29. I didn't understand your message that you sent me, that you said you gave me paperwork.
Paperwork, this paperwork here was what Richard, this is what Richard had me bring you.
Yeah, I was. He had.
Okay. Watson.
Mr. Platten?
Yes, can I be excused?
Yes, yes, sorry.
Thanks, Judge.
All right, sorry about that.
Bye.
Mr. Ashmore? All right, Mr. Ashmore's not with us online anymore. So Noel, you're back.
Brief conversation with Larry Watson today.
Is he in the jail and available?
He should still be in the room, I think. He's indicated that one.
Hang on, let's do this. CR 17-392 State versus Larry Allen Watson. If Mr. Watson's in the jail court, will he step up, please?
He's here, Your Honor.
All right, and I'm gonna tell you what, if you'll grab that microphone, because I don't think that they're not hearing very well at the jail. All right, go ahead, Mr. Noel.
I met with Mr. Watson Sunday morning. We reviewed the motions that morning. I indicated some options that I thought might be available. Stated previously offered waiving a hearing 40 years. I made a suggestion otherwise this morning for the possibility of safety and catching up fees. That was a second offer that was made today. The probation officer, sorry, I don't know, her first name Stephanie, that she was agreeable to that. Mr. Watson, well, two things. One, wanted to think about it, this is the same concept I gave him on Sunday, today is Tuesday, and that he wanted to hire a lawyer, which is fine with me. And that lawyer files a motion to withdraw and substitute.
Well, wanting and doing, same speech I give my kids all the time. Two separate things. So has he hired an attorney?
No.
All right, so you're his attorney. So he's rejected the offers from the state.
At this minute, that's my understanding.
All right. So we'll schedule Mr. Watson for his contested hearing this afternoon. All right, so we can send Mr. Watson back to his cell and we'll bring him back at 1:30. And we may make arrangements to have him brought over to the court so we can have a contested hearing on his motion.
You'll be going over to the
Ms. Abraham. I'm gonna take a 15-minute recess to meet with Ms. Curry and Mr. Bingham on Mr. Joshua Martin in chambers. And then I'll be back shortly. And then we'll take up, let's see, who else do we have remaining out there? Basil Sotelo and Mr. Martin, correct?
Yes, sir.
Mr. Perez.
We've
And then
handled it.
And then Perez, we're gonna do the plea.
Joshua,
Jonathan has, yes, sir.
okay,
Jonathan has his paperwork.
okay, all right, I'll be back in just a moment. Mr. Ashmore?
Good morning, Judge. Sorry about the technical issues.
Hey, no problem. I understand that you've had a family emergency.
To be
correct?
specific, yes, Judge. Well, to be specific, Mike Donegan, a very close friend of mine, commander of our American Legion post for many years, passed away. And as current commander of the post, I need to be available to help the family through the next couple of days. So I apologize for not being there in person, and I filed motions to continue, but I'll just wait for the court to go ahead and call the cases. And I appreciate the court allowing me to appear by Zoom this morning.
Okay. All right. We'll go ahead and call our jail case first. Basil Sotelo. Ms. Sotelo will step up. All right. Cause number CR 16437. Ms. Sotelo is in custody on the state's motion to revoke. Go ahead, Mr. Ashmore.
Good morning, Judge. I had filed a motion to continue, but I don't think the court's had any opportunity to rule on that yet. But just briefly, we were appointed on her case just within the last several weeks. Ms. Sotelo has had an opportunity to discuss with me the state's motion to revoke offer. We have not yet discussed in writing any kind of resolution to that. It is our understanding the state is offering TDC or state jail as a resolution, but again, nothing is as of yet in writing. I'm just asking the court to continue this so I can attend to the affairs that are required of me during this week due to Mr. Donegan's passing.
State.
State has no objection, Your Honor. Mr. Ashmore was discussing this case with me.
Use your microphone. Oh, you got it. Okay.
Prior to personal events interceding, so we have no objection. We believe that this.
All right, court will, and Ms. Sotelo, I haven't asked you anything yet. You understand the announcement that Mr. Ashmore is making, and are you in agreement as well?
I guess so. Yeah.
You guess so? You understand that?
Yes.
He's asking to reset your case and give you more time to work with the state?
Yes, sir.
Okay. Do we believe that we're going to reach a resolution in this case?
It's been indicated to the state that Mr. Ashmore does believe it will be resolved without hearing.
Here's why I asked Mr. Ashmore is I can set it sooner than July 29th. If there's not going to be an agreement, then I would set it on the 29th for a contested docket. However, if we believe that we're going to reach an agreement, I could set it here in a couple of weeks or sooner.
Judge, I'm good with sooner. Let's take some action and resolve this for Ms. Sotelo. This has been pending on her for long enough, and I'm comfortable with working with the district attorney's office and resolving this. It's just, we set it on this contested docket because we thought we would have one today, but things have diverted my attention.
All right, so this is what we're going to do today. I'm going to set Ms. Sotelo. Are you available on Tuesday, July 13th? That's 2 weeks.
I'm looking right now, Judge. Give me just a moment, please. Judge, that's good for me.
All right, so I'm going to set it for the 13th of July. And if there's no agreement reached on that date, just so you have notice, I'm going to set it 2 weeks after that for a contested hearing on the 29th.
Thank you, Judge.
Okay, so I'm not filling out a notice of appearance since neither one of you are in the courtroom. So July 13th at 1:30 will be your next hearing, Ms. Sotelo. Okay.
Thank you so much, Judge.
Yes, sir. Thank you, Judge.
Thank you, Mr. Abraham. Kobe Heron. CR 18263 State versus Kobe Alton Heron, also set for motion to revoke. Go ahead, Mr. Ashmore.
Judge, this same request for continuance is filed for the exact same reasons. I had been working with the state district attorney's office to come up with an offer. Mr. Heron has an unresolved offense at this time that I am not appointed on, and I'm not sure where it is. And that was really the only thing that was holding up our plea negotiations. We do believe this one, like Ms. Sotelo, will be resolved by agreement, but until that unresolved, or I don't know if it's unindicted or working its way through the grand jury process or an information process, I believe it's a misdemeanor DWI, but I know that is pending, and that was the reason why we just went ahead and set it on this contested, to give ourselves some time to work on that and negotiate with the state. However, like same request for continuance. The recent events in our post have just prevented me from focusing on this as I normally would, Your Honor. I'd also, oh, sorry, Judge, I'm sorry.
Go ahead, State.
Judge, we have no objection. I would note for Mr. Ashmore's information that the DWI has been filed and Mr. Heron has been appointed to the Sawyer in the town of Burton. So if you want to coordinate with him, and I have no doubt we will reach a resolution.
Do we know when the misdemeanor case is set? Do we have the paperwork on Ms. Dickinson?
Yeah, sure.
Can I go ahead and see that while we're waiting on? Yes, please. I'm not ready to call the case. I just need the paperwork to review it while we're waiting. Don't know, Mr. Woodward.
Sorry, Judge.
I just don't want to set it before the misdemeanor case. If it's not going to help.
It's set 7-7.
7-7. Okay. All right, then we'll set Mr. Heron then on Tuesday, July 13th.
Thank you, Judge. 1:30 again, Your Honor.
If Mr. Heron's going into custody, yes. If not, it'd be at 9 a.m.
Okay, Judge. Thank you.
Because he's not in jail at this time.
No, Judge, he's not.
All right, Mr. Heron, deputy's going to bring this to you, sign where it says defendant, and then we're going to give you a copy of it. It says you're coming back on July 13th. All right, is that all you have, sir?
Yes, Judge, thank you.
All right, have a good day. Sorry,
Thank you so much, sir.
sorry to hear
I
about
do appreciate that.
You're welcome.
Thank you so much, Judge. Have a good, I'll see you Thursday.
Okay.
Your Honor,
Yes, ma'am.
we're ready on Joshua Perez's plea when you are.
Okay, just a moment. We have an update on Mr. Bahina's, you're now clean. All right, Mr. Bahina, back to the podium. All right, back on the record, CR 18456, State versus Julian Martin Bahina. I don't believe I issued a new reset date, have I?
I was saying July 27th. That's what I'm putting down back in January.
Should be July 29th. All right, Mr. Bahina, I'm going to set you for a contested hearing on July 29th. We're also, if you do not reach a resolution in your case, and if there's any request for continuance of the case, we're also going to take up the conditions of pretrial release that we have with Mr. Bahina on that date. So if there's no resolution on that date, we're going to take up the issues of him committing violations while he's on bail in this case.
Judge, other than the new violations, is the floor where, any other way you may need to leave your money or.
I don't have any notes otherwise from the probation department. All right, Mr. Bahina, you're still on probation. You're still required to report, follow all your conditions. You're free to go. All right, CR 19272, Joshua David Perez. Do I have that paperwork, Mr. Manning?
Judge, I've just received it via email and printed it out in my office. I was going to bring the copy over for state signature and judge's signature after we did the plea.
Okay, can you tell me the terms?
Yes, Judge. Plea agreement has been reached to plead true to the state's motion to revoke punishment be assessed under 1244A at 60 days confinement in Van Zandt County Jail with credit for time served and balance of financial obligations.
All right, give me a second. Let me pull up his case so I can see that motion. All right, Mr. Perez, if you'll raise your right hand, I'm going to place you under oath. Mr. Perez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you put your hand down. All right, Mr. Perez. In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, Your Honor.
Feel like you've had enough time to discuss the state's motion to revoke and have all your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, Your Honor.
Is that your true and correct signature throughout the documents?
Yes, Your Honor.
Mr. Manning, do you believe Mr. Perez to be competent today?
I do, Judge.
Mr. Perez, you appeared before the court on January 28th of 2020 and pled guilty to a state jail felony offense of possession of a controlled substance. Court reviewed the evidence that day, found there was sufficient evidence to convict you of the offense. The court did convict you of that offense, assessed your sentence at 2 years confinement in the state jail division of TDC, and also assessed a $1,000 fine. Court later suspended that sentence and placed you on community supervision for a period of 2 years. It was during your term in condition of community supervision that the state filed its motion to revoke your community supervision, alleging in a single count of a violation. Mr. Manning, does your client waive the formal reading of the state's motion to revoke?
He does, Judge. He understands the charge against him. We've also gone over the offense report that's associated with that count.
All right, Mr. Perez, then how do you plead to count one as contained in the state's motion to revoke? Is that count true or not true?
True, Your Honor.
And are you telling me it's true because you have violated your terms and violated the terms and conditions of your community supervision?
Yes, Your Honor.
All right, court will accept the defendant's plea of true at this time. Mr. Manning, any objection to State's Exhibit A?
No objection, Judge.
All right, State's Exhibit A is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, we would just note for the record, because it's not 100% clear.
Will you turn that microphone?
Judge, we would note for the record, because it's not 100% clear, that the one alleged is in fact a Class C misdemeanor. And we have nothing further beyond that.
Thank you, Mr. Woodwhite. Anything further from the defense?
Judge, I would just let the court know that I've admonished Mr. Perez about the financial obligations that will be due once he is released. I told him how to make arrangements with the court collections officer there in the courthouse. And he understands that he does have his obligations once he is released today.
Does he understand that I will have him arrested if he doesn't pay?
He does, Judge, and I admonish him of that fact strongly.
Thank you, Mr. Manning. All right, then based on the evidence presented to the court will follow the plea agreement in this case. The court hereby revokes Joshua Perez's community supervision, assesses his punishment under section 1244A of the Texas Penal Code at 60 days confinement in the Van Zandt County Jail. Court will award Mr. Perez 60 days credit for time served. Court orders him to pay the balance of his financial obligations. Mr. Perez, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Go with the bailiff to be fingerprinted, and then as soon as you get released, I expect you to be in the courthouse making a payment and a payment plan. You understand?
Yes, sir.
Judge, would you like for me to send this paperwork to Ms. Abraham or just bring it up myself?
Just Ms. Abraham will be fine.
Okay.
Ms. Dickinson, Ms. Fox, CR 13-6. Yes, please. All right, Ms. Dickinson, if you'll raise your right hand. Ms. Dickinson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can put your hand down. Ms. Dickinson, you appeared before the court on October 27th of 2016, and you pled guilty to the offense of accident involving injury, felony offense. The court heard the evidence on that date, found that there was sufficient evidence to convict you. However, the court followed a plea agreement that you reached with the state at that time and deferred a finding of guilt in your case and placed you on community supervision for 5 years. The court did not assess a fine, but did assess court costs and restitution. During the term of your community supervision, the state has filed an amended motion to adjudicate and revoke your community supervision. Have you had enough time to review that motion with your attorney, Ms. Lisa Fox? And you feel like you've had enough time to have all your legal questions answered by her? Are you pleased with her representation of you? Now, earlier today, you indicated, or Ms. Fox indicated to me that you were wanting to change attorneys and you were not wanting Ms. Fox to represent you. Is that different at this time? And how is it different and why is it different? So you wanted to change attorneys because you felt like you could get a better deal? Say again, I can't hear you. You were told you were told you could? But it's been made clear to you today that the offer is not getting better from the state. Is that correct? And so I'm saying, has it been made clear to you through Ms. Fox that the state's not making a better offer to any other attorney? Is that what you're telling me? Okay. And Ms. Fox, do you believe Ms. Dickinson to be competent today? And can you elaborate more on Ms. Dickinson's response regarding the plea offers and her deciding that she wants a different attorney earlier today?
Yes, we've discussed all the options, and of course, this one or two attorneys told her they paid him or her that they would get that she would go to help, and we discussed it. She knows that the state is not a judge.
And you've consulted with the state and they've indicated to you that they're not making a different offer. Is that correct? And I think, I don't know if I asked you, but you do believe your client to be competent today? And you've explained to her her legal and constitutional rights?
Yes.
All right, and state at this time, is it true that the recommendation before the court is the best recommendation that the state is going to offer in this case?
Yes, Your Honor, I can certify with 100% certainty we did not offer anybody else any better deal. Fox has done an admirable job.
Thank you, Ms. Heisel. All right, Ms. Dickinson. Ms. Fox, does Ms. Dickinson waive the formal reading of the state's motion to adjudicate?
Yes, Your Honor.
All right, Ms. Dickinson. This time I'm going to ask you, how do you plead to counts 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 13? Are those counts true or not true? And Ms. Dickinson, are you pleading true to those counts because those counts are in fact true and for no other reason? Has anyone threatened, forced, or pressured you to plead true today? All right, court will accept the defendant's plea of true to each count. Ms. Fox, any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A? All right, State's Exhibit A is admitted into evidence. The court does take judicial notice of the defendant's judicial confession. Anything further from the state at this time? From the defense? All right, based on the defendant's plea of true and the evidence presented in State's Exhibit A, the court will find that Christian Rochelle Dickinson has violated the terms and conditions of her community supervision. Court will follow the recommendation of the state in this case. The court, upon the finding that the counts are true, hereby revokes Ms. Dickinson's community supervision, adjudicates her guilt, places her in the custody of the Texas Department of Criminal Justice Institutional Division for a period of 3 years, and orders her to pay the balance of her financial obligations, including restitution in the amount of $91,227.55 and court costs in the amount of $140. Court also awards Ms. Dickinson 190 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Dickinson, you're hereby remanded to the custody of the Vincent County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward here with the deputy to be fingerprinted and then take Ms. Dickinson in custody, please. Yes, sir.
Thank you.
All right, Ms. Tabraham, if you can bring Mr. Martin up. All right, this is cause number CR. Good morning, sir. This is cause number CR 19-180, CR 2398, State versus Joshua Mac Martin. And we are set for motion to revoke today. It's my understanding that the state and defense are recommending to the court a resolution in this case. Is that correct?
That's correct. We have three recommendations for the court. We have true to all of the violations except the one elected to DWI, which the state will abandon all the other violations, that Mr. Martin's probation be amended to extend it for 2 years to add the.
Miss Curry, they can't, you turn that on. They can't hear you in the jail.
Here.
And I'll tell you what, if y'all want to approach closer, you can. They can't hear. I don't know if it's the microphone. There's a microphone here. And do we have the paperwork?
We submitted it last time, Judge.
Ms. Tabraham, did the court retain the paperwork on Mr. Joshua Mac Martin last time? Do you know?
No, sir.
Ms. Barker, will you scrounge around on my desk and see if by chance it's there in front of my monitor? And if it is, will you bring it?
Oh, we do have a copy of it, Judge, signed.
Signature.
No, I'm looking for the plea papers.
Yeah, we have the,
We have a copy of it. We have, if we can give to you.
Let's wait and see, 'cause I think
Okay.
we may have it. All right, Mr. Martin, while we're waiting on that, if you'll raise your right hand, sir, I'm going to go ahead and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. I'm sorry, I didn't hear you.
Yes, sir.
Okay.
Yes, sir.
Okay, thank you. You can put your hand down. All right, Ms. Curry, and just start over what the state's recommendation is.
yes, Your Honor. The agreed recommendation is that upon a plea of true to all of the allegations in the motion to revoke, except the allegation alleging a new DWI offense, the state will abandon that allegation. Upon a plea of true to the remaining allegations, that Mr. Martin's probation be extended for a period of 2 years, that he be required to have a scram device that detects any use of alcohol, that he be on intensive supervision for the purpose of the weekly substance counseling, in his case dealing with alcohol, that he be required to serve 180 days in the Van Zandt County Jail, which he has already accrued credit for, Judge. And that he abide by all the other terms of his original probation.
And is there an agreement or a recommendation regarding his community service? I know at the last time there was a mention of that, and I think I indicated that I wasn't comfortable giving him community service hours for work that he did in the jail. Is that an issue at this time?
The state will leave that to the court, Judge. It was our original. He has done, according to what the sheriff's office told me, he has done vastly more hours of work for them than what would be required of his community service. One of the allegations is that he was behind on community service significantly before he went to jail. The state is willing to allow his work in the jail to be credited towards that past community service, not towards future community service. But we'll leave that to the discretion of the court.
But there's no adding community service. Is that correct?
That's correct, Judge.
Do we know how many hours he was assessed and how many hours that the jail has provided that he's done that you're recommending? I mean, I'm not sure I'm going to do it anyway, but I'm just wondering about the math on it.
He was behind 177 hours, Judge.
Do you know how many were assessed? This was a third.
A 6-year probation original.
$400 hours.
Judge, I would say he's up there 180 days. He's probably has well over, probably close to 1,000 hours of things he's done over there. If the court even gave him 150 hours credit for something towards not his whole 400 hours, which is something sufficient, we'd be very happy with that. But I understand it's in court's discretion.
Okay. All right. And I believe that at the last setting I asked, I inquired about a drug evaluation. That was one of the allegations, that a drug evaluation had not been conducted. That was a violation of his community service. And I believe that I directed our community supervision department to have one ordered. And I believe I was made known that it was made known to me that we did not have an evaluator present. And then I reached out through counsel to Mr. Bingham and asked for an assessment to be done to assist the court. And has that been done, Mr. Bingham?
Judge, it has, we have a licensed clinical defense counselor, master's level, Lisa Danley, it's LESADANLEY. She did administer some tests. It's called the SASSI-4. She has the screening results for those. She also went back, did some historical data, talked to him one-on-one. We're prepared to have her testify. I think she's ready to go for whatever court's ready.
Okay. And if you want to have a seat, that's fine. You stay here. I don't care. It doesn't bother me. But just make sure your microphone's on because they said they can't. Are y'all, Mr. Martin, are you able to hear Mr. Bingham when he speaks?
Yes, sir.
Is it clear or is it real low?
It's a little low, but I can
A little
understand him.
Okay, we'll just make sure the microphones are in use and speak up. All right, at this time, I'm going to bring Miss Danley in. Yeah, Miss Stanley is not connected to audio. All right, here, we have it now. Let me.
There we go.
Stanley.
Okay.
All
I've got
right.
it.
All right, thank you. All right, Ms. Stanley, you've been invited to testify before the court today. I'm going to ask that you raise your right hand. I'm going to place you on your oath. Ms. Stanley, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, in the courtroom, Mr. Matt Bingham and Ms. Tonda Curry are here. Mr. Bingham's going to ask you some questions. If you cannot hear, just say so and we'll make adjustments. Go ahead, Mr.
Yes,
Bingham.
sir.
Thank you. Ms. Stanley, can you hear me okay?
Barely.
Barely? All right. I'll talk louder. Can you hear me better at this?
Yes.
All right. I feel like a Verizon commercial. If you would tell the court the training and background you have that allows you to serve your position as a licensed chemical dependency counselor.
Yes, sir. I am a master's level licensed chemical dependency counselor. Experienced with crisis counseling with the local authority with Lake Regional over 12 counties with homicidal, suicidal, psychotic, substance abuse, and special needs individuals. And I also have experience with as a CPS contractor doing in-home kinship studies. So I have a wide variety of experience to draw from.
Your practice has been mostly clinical, not forensic, not in the courtroom setting so much as it has been more clinical work. Is that fair?
Correct.
Okay. In fact, is this your first time to testify?
Correct.
Okay. If I ask you something you don't understand, just ask me to repeat it. I'll be happy to do so.
Okay.
You know Josh Martin to the extent that you have administered testing to him and you have talked to him on a separate occasion. Is that true?
I'm sorry, I didn't hear the whole question.
That Josh Martin, the defendant in this case, did you have an occasion to administer testing to him?
Yes, correct.
Did you have an occasion to go back and talk with him for the purpose of gathering kind of historical data or clarifying whether or not he actually in fact understood questions on a portion of the SOSI test?
Yes, that's correct.
When you met with him and administered the test, what test did you administer?
I administered the SASI-4. It's a substance abuse subtle screening inventory. It has it's to identify probability of substance use, or in this case, like acting out, has a 92% reliability rating, and it is it's based on empirical studies. It's a true, false questionnaire, as well as other questions that are answered as far as like never, once or twice, several times, or repeatedly. So he would give just those answers.
Do you have a chance to elaborate on the questions or interact with him during the testing?
Not during the testing. It's not, I'm not allowed to do that to influence the test. And I can't really redo the test because after he's heard the question, he has a chance to think about them. But when something comes up positive like that, like the acting out on that test, that's just an inventory. Again, it's a subtle screening inventory. So it's designed to pick up subtleties to let the clinician know that might be somewhere they need to look at. So there needed to be a clinical assessment done, whether it's with substance abuse or acting out. So that just kind of puts the clinician in a direction to look for issues. So having that being said, then I did the evaluation with him, and with my experience with all across the different boards, I was able to, I checked his history. I checked over the questions on the SASI that were kind of related to behavioral, and asked him to give more detailed explanation. And in doing that, I saw no evidence of history of acting out or probability of acting out. I believe the SASI just picked up again it picks up subtleties, and it just picked up on some questions that may have been weighted heavier. But with the answers he gave me, there was no concern.
And I appreciate that. I think that cuts down on the questions I need to ask, because I think I understand the SASE kind of points you in the direction of somewhere you need to develop more clinically. You did that with him, and what originally was indicated there could be a problem with acting out, after you clinically evaluated him, talked to him, you do not see a problem with him acting out for purposes of maybe acting impulsively or not following the rules. That's not a concern with you and Josh Martin.
No, sir. Again, that the SASE is not meant to be a fast rule, because even if it were to pick up like on substance use, you still need to do an evaluation, because we could all have tendencies towards it. Doesn't mean we're doing it or have done it or will do it. And same thing with the acting out. It's just to kind of lead you in a direction to kind of do a little bit more evaluation. Did I answer your question?
Based on the SSI core screening or test that you administered, along with your historical talking to him, developing a more clinical aspect of it, do you believe that he has an alcohol or drug problem?
No, sir.
Do you believe that he has a prescription drug use problem?
No, sir.
Do you think that he is that he has an element of defensiveness that would indicate evidence of a problem?
I mean, according to the assessment and my evaluation, I saw no evidence. No, sir.
Okay. So is it fair to say that Josh Martin is an individual who finds himself incarcerated after being on felony DWI probation, but as far as any red flags that the judge was to put him back out on probation, there's no red flags popped up for you? Is that fair?
That's fair. No, there were no red flags.
Okay. Do you have any concerns? I noticed that after you did the clinical assessment of Josh, you issued a new chart note, but in findings of additional assessment evaluation on June 25th. And third paragraph from the top, you stated, after this assessment evaluation, you did not see enough evidence of problems with impulse control to substantiate Josh being a high risk for acting out or a danger to himself or others.
Correct.
I mean, there's really nothing you saw in the testing or clinically that indicated to you that he would be a danger to himself or others should he be returned back to probation. Is that a fair?
That's fair.
Judge, we also, we did.
That's fine. You can stay seated.
Okay. We did provide the court and Mrs. Curry an email documents that Mrs. Stanley had provided to us. One of them were documents generated on June 22nd as a result of the testing. And then there was a document for the 25th that was findings of additional assessment. I did not bring copies with me, though I did, I marked all over, but we would ask the court, if the court's inclined to make that part of the court's file, take judicial notice.
All right, the court has received the paperwork provided, the reports provided by Ms. Stanley. The court will take judicial notice of it, and the court will cause it to be included with the papers in the clerk's file.
We'll pass this.
Thank you, Your Honor. Ms. Daly, my name is Tommy Curry. I'm the GA here at Canton, and I have a few questions for you, okay?
Yes, ma'am.
Can you hear me all right?
Yes, ma'am.
All right, good. So I reviewed your report in this case, and I will tell you that the portions of your first report that stuck out to me were not necessarily the portions that had to do with the acting out measures of the SASE test, but it were some other things and that stuck out to me, and I'd like to visit with you about those. First of all, the SASE is a self-report test. Is that correct?
There is a self-report test, but I have a clinical test that you have to be licensed to get.
All right, can you repeat that? You said it is a self-report test, but what?
I think there is one, but it's not the clinical. It's not the one that clinicians would use.
Okay.
I'm really not that aware about the self-report because the one I have, you have to have credentials to get. And I've had special training to score it.
Right, and maybe I phrased my question not in the correct terms for your field of education and expertise. When the subject taking the SASE, using the SASE tool, they answer the questions on their own for themselves. They self-report what their answer. Is that correct?
Normally they would, but we did this via Zoom. He was in prison or in jail at the time. So I asked him the questions and answered for him.
Okay, so I have what I believe is the SASE that is part of the court's file here in front of me. First question, people know they can count on me for solutions. The answer was true. So are you saying that you and Mr. Martin were on Zoom, you read that question, he told you check the true box?
Correct.
Okay, so the substance of the answers are what he told you. Correct?
I'm sorry?
So the substance of these answers, what are what he gave to you, correct?
Yes, I would read the question or statement and he would answer true, false, or whatever other options there were.
And then there is a scoring system. You put these answers into a computer system and it gives you the score and tells you where this person falls on the various measures that are included in this test.
Correct. Again, I'm in the clinician website, so it automatically scores when we complete the test and I automatically get the results.
Sure. And I guess what I'm getting to is the reliability of these results is only as good as the truthfulness of the person being tested, right?
Correct, but this is a empirical, it's based on empirical studies, 92% accuracy rate. It is set up to catch profile validity, to check and see if there's random answers. It's got similar questions to kind of go back and forth and check against each other. So it's set up to be 92% accurate.
Sure. And it's set up to be 92% accurate when the person is honest. And by that I mean you could have a serious daily heroin user addict take this test, and if they answered the questions not truthfully, but they could answer the questions in such a way that it would show they did not have a problem.
Okay, again, this is a subtle inventory. This is not to diagnose. This is something that you would use if I had a client come in that maybe we just want to see. We use it as a tool to show them if they're in denial. See, this is showing that you have a tendency towards this. This is not something to diagnose. A diagnosis should come from a licensed clinician, not the inventory.
Okay, very good. So my question for you is, if you knew that Mr. Martin had 4 or 5 arrests and 3 convictions for driving while intoxicated, would you be concerned that when he answered the question, drinking causes problems between me and my family. The answer to that question is false. I wish I could cut down my drinking. False. My drinking is making my problems worse. False. Does that cause you any concern with the reliability of this test?
I didn't hear everything you said. I'm sorry.
Did you have any concerns with the answers to these questions, knowing that Mr. Martin had been convicted of DWI 3 occasions, arrested on 4 or 5 occasions? Did you have any concerns with any of his answers?
Yes, sir. Yes, ma'am. I mean, I'm aware of his DWIs. I'm aware of his arrests. I'm aware of his history. Again, I went back and researched the history. The history I wasn't concerned as much about because they were spread out. And no, I know one of them, it was dismissed and he was actually below the legal alcohol limit. So I take a lot into consideration, not just the surface. I'm going to go back, I'm going to check the history, I'm going to check exactly what happened, when, how, why, and use all that information to make an educated decision.
And that's kind of what I'm getting at, and I'm not trying to under the conclusion you came to. I'm just wondering if my concern, if there is a reason why I shouldn't be concerned by some of these answers that stuck out to me.
Okay, I'm not sure if you received the evaluation, but I did address every one of the questions that were of concern, especially with behavioral.
Right, and I know you addressed the ones about acting out. I just had some concerns about some of the other questions.
Okay.
The cage questionnaire. Have you ever felt you should cut down on your drinking? And he answered no. Have you ever felt bad or guilty about your drinking? And he answered no. I would think that most people who've been arrested 5 times for DWI would answer yes. Does that not cause you any concern?
Again, that was in the evaluation that I did. We did discuss that. He discussed that he did regret his decisions. He discussed that he was never going to do it again. He realized it took time away from his kids. And even though, you know, this instance says, did he regret taking the drinks? He just had a couple of beers, usually at a ball game, or it wasn't, you know, it wasn't, you have to take a lot into consideration. He wasn't doing it. He doesn't, I mean, it kind of makes him sound like he's an alcoholic, and he's not. He just had some unfortunate circumstances that it could happen to any one of us. But I get what you're saying. How he answered on the SASE. And that, again, is a reason why you need to have a clinical evaluation to double check those answers, whether they're right or wrong.
Thank you, ma'am. I'll pass it.
Mr. Bingham, any further questions?
No, we're we have no further questions.
All right. Thank you, Ms. Stanley. Appreciate it. You're free to go.
Thank you.
All right, Ms. Curry, I don't believe I have the paperwork from this.
They informed me, Judge, that they didn't keep it. We're redoing it because we're actually adding in. So Stephanie's working on it to print out.
Okay. All right, Mr. Martin. In cause number CR 19-180, you appeared before the court on December 19th of 2019. You pled guilty to the third-degree felony offense of driving while intoxicated, third or more. Court heard the evidence, found that the evidence supported a conviction in this cause, and the court followed the plea agreement at that time and found you guilty of that offense and assessed your punishment at 8 years confinement in the institutional division of TDC, along with a $2,000 fine. The court subsequently suspended that sentence and placed you on community supervision for a period of 6 years. It was during that term and condition of your, during the period of your community supervision, that the state filed a motion to revoke your community supervision on December 3rd of 2020 and alleged, as I'm having it displayed to you, and has alleged in 6 separate counts, various ways that you have violated the terms and conditions of your community supervision. Have you had enough time to speak with your attorney, Mr. Bingham, about this motion? And do you feel like you've had enough time to have all of your legal questions answered?
I believe so, yes, Your Honor.
Are you pleased with Mr. Bingham's representation of you?
Yes, sir, I am.
Mr. Bingham, do you believe Mr. Martin to be competent today?
Yes.
And does he waive the formal reading of the state's motion to revoke?
He does. We obviously to the count one was being abandoned by the state. And he's prepared to enter a plea counts 2, 3, 4, 5, and 6. Does not need to read that.
Thank you, Mr. Bingham. Mr. Martin, I'm going to ask you at this time then as to counts 2, 3, 4, 5, and 6. How do you plead? Are those counts true or not true?
True.
And Mr. Martin, are you pleading true to those counts because those counts are true and for no other reason?
Yes, sir, Your Honor.
All right, court will accept the defendant's plea of true at this time. Mr. Bingham, any objection to State's Exhibit A, the defendant's waiver of rights, plea of true?
No objection, Judge.
All right, and once that's signed by Mr. Bingham, then we'll have that to be. Have you gone over that with your client, Mr. Martin?
I have.
We'll have to, Mr. Bingham will have to watch the jail and have his client re-sign.
That'd be fine. Mr. Martin, have you had an opportunity at our last hearing to review your waiver of rights and plea of true document with Mr. Bingham?
I believe so. I'm not sure which one that was, but we've talked about a lot of things on there.
Okay, just one moment.
The waiver of rights portion, Your Honor, is identical to the portion that they signed, that Mr. Bingham has a copy of when we were here 2 weeks ago. We did flush out the plea agreement part a little bit more, but the waiver of rights is identical to what previously signed.
Okay, and Mr. Bingham, as the officer of the court, is it your statement, testimony before the court that you have reviewed the waiver of rights with Mr. Martin, explained to him all of his legal and constitutional rights, and you would join him in waiving those rights for consideration of the plea agreement today?
Those we have this waiver of rights, the consequences of pleading true to the allegations of the state's motion to revoke. We've gone over the constitutional rights he enjoys, someone accused of a crime, and his constitutional rights, what to expect here in the court today. We've discussed those at length.
All right, then the court will accept and admit State's Exhibit A, the defendant's waiver of rights, plea of true. Will direct Mr. Martin to sign those. Mr. Bingham, as officer of the court, asks that you take that document and review that document with Mr. Martin and obtain his signature.
Yes.
Anything further from the state?
Nothing to state, Your Honor.
All right, the court, anything further from the defense, Mr. Bingham?
No, Your Honor, we addressed, we were going to call the defendant, we're going to pass on that, go ahead and rest.
Okay. All right. then the court, having heard the evidence and accepting the plea of true, finds that Mr. Joshua McMartin in cause number CR 19180 has violated the terms and conditions of his community supervision. Court will follow the plea agreement with regards to, I think, majority of the recommendation. And the court will entertain any objection from the state or the defense. Court will, upon finding each violation to be true, the court will continue Mr. Joshua McMartin on community supervision. Court will extend his community supervision for an additional 2 years. As a condition of community supervision, the court will impose the placement of a SCRAM alcohol detection unit on to Mr. Martin. Court will order him on to intensive supervision as directed by the Van Zandt County Community Supervision Corrections Department. The court will order Mr. Martin to serve 180 days in jail as a condition of community supervision. Court will issue him credit for time served towards that condition of community supervision. Is the state also, with regards to CR 2398, is there a disposition on that charge? CR 2398?
Yes.
What's the?
DWI, yes, Your Honor. So I think I already filed a motion to dismiss on that, but we will be for that.
All right, court will grant the state's motion to dismiss in CR 2398. So, Mr. Martin, I want to take an opportunity to tell you that Mr. Bingham and Ms. Curry believe in you, and they have indicated to me that they believe that you will, if given this opportunity, that you will be successful in completing your community supervision as originally ordered. I'll tell you that I have concerns about it. And obviously, you know that from the last hearing that we had, and I voiced my concerns. It bothers me that you're on community supervision for driving while intoxicated, and then you get accused of committing a new violation of driving while intoxicated. It concerns me that you weren't doing your community service. You didn't do your evaluation. You didn't do your drug offender class. You didn't have your interlock device put on when you were supposed to. Based on the evidence that Mr. Bingham has brought to me with regards to the new offense, and also the testimony of Ms. Danley as the substance abuse evaluator, I'm going to go out on a limb here. And I'm going to give you this opportunity to prove to me that you're a good risk. And if you so much as to drink another beer and that SCRAM device goes off, don't come back in here crying. Don't come back in here with anything other than expectations of going to prison. And I want you to understand.
Yes, sir.
Because I have it. Well, I hope you understand. I thought you understood the first time. I thought you understood the first time.
Yes, sir.
Maybe you didn't, but you should have. All right. So this is not baseball. It's not 3 strikes. But we're not playing any games like that in here. All right. This is about this is a second chance. It's going to be granted to you by the court because of Mr. Bingham, because of Ms. Curry's combined recommendation. And I know that you've done quite a bit of work while you've been in the jail. I'm not going to give you any credit towards that, towards your community service. I'm going to expect you to get out in the community and keep doing that same level of work for the community. Okay?
Yes, sir.
And so,
yes, sir. Thank you, Your Honor. I appreciate it.
You're welcome. You're welcome. And so for me, Josh, actions are going to speak louder than words. If I don't see word anymore in the probation department, I'm going to keep my thumb on you, and if I'm going to be checking on you behind the scenes, and all I want to hear is good things. And you know what? This is a man that should have gotten a second chance, and he's taking advantage of it. That's what I want to hear. I understand that you have young children in a family that are relying on you. Is that correct?
I have a 9-year-old son and a 20-year-old.
Yeah.
Yes, sir.
So Do you, I mean, you know, a father in jail is not as good as a father out in the community and at home, correct?
Sure. Yes, sir, I understand that.
So you've got a whole lot more riding on it than just your freedom, as far as I see it. All right, so no more excuses. No more excuses. I've done my job. It's time for you to do your job. And if you don't hold up your end of the bargain, I promise you I will uphold my end of the bargain. Are we clear?
Yes, sir, we're clear.
All right.
Thank you again.
You're welcome. You're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. It may be a little while before I get some paperwork over there. You're going to have to be fingerprinted, and you're going to have to sign some additional documents. I believe Mr. Bingham's probably going to be heading over there. Deputy Ragsdale, I'd asked that you ask the jail staff if they would make an exception for Mr. Martin and Mr. Bingham so that he can remain out, so he can finalize his paperwork so that he can be processed out. And so,
Sure.
when do you want Mr. Martin to report this afternoon? As soon as you get released, Mr. Martin, I want you to head straight over to the probation department. And the scram device be placed on at the department or at the jail? Okay, all right. So, and you'll be given more information by the probation department on getting that scram device placed on you. All right. So go ahead.
Yes, sir.
I'm going to have you go back with the bailiff there, and then we'll have that paperwork over, and then you'll be processed out soon.
Thank you, sir.
You're welcome. Is Jacob Frericks here? Jacob? Thank you, Mr. Bingham. Good to see you. Mr. Frericks, this is cause number CR 2163. You are charged by indictment with a state jail felony offense of possession of controlled substance in penalty group 1, less than 1 gram, that carries a range of punishment if convicted and sentenced of not less than 6 months or more than 2 years confinement in state jail penitentiary. Are you going to hire an attorney to represent you? With a couple today. So if I reset your case, you believe that you'll be able to come back in here with an attorney? And who are you meeting with today? Okay. All right. So what I'm going to do, Mr. Frericks, then I'm going to reset you until July 13th. That's going to give you about 2 weeks. All right. And I expect you to come back with an attorney. All right, Mr. Frericks, I'm going to have the deputy bring this form to you, sign it, and we're going to give you a yellow copy, and it has your next appearance date. Yeah. Ms. Daly. All right, Ms. Daly. So the probation department has reported to me that you did what I asked you to do. Okay, so I'm going to ask you to do it again.
I sure will.
All right, let's.
I'm already a month ahead on my work week. I paid $120 on the 25th for July.
That's great. All right. So what I'm going to do is I'm going to reset you, come back in a month on July 27th. It's a little less than a month, but I want you to do the same thing. Make your same payments, do your same community service.
Cost to pay and the 10-hour community service to do.
We're good. Well, let's stay on top of it and let's get it done and get you done.
Yes, sir.
All right. So I'm not going to give you a notice Actually, I will. I'll give you a notice. I'll ask Miss Officer Mature to help me out if you fill that out and then just have her sign it. It's probably up under that. It's up under that laptop for you. All right, Ms. Daly, you can come on back here with Officer Mature. Thank you.
That's my mother.
Right.
And the road starts, you have to see both platforms. Thank you very much.
Is Ullman Pazlera? Ullman Pazlera, I called his name earlier. He was not here. Oh, 1:30?
This is what my docket shows.
Yeah, I don't show that at 1:30. But let's look him up. Mr. Knoll, do you have someone else? Okay. I always recommend eating lunch. What are calories? Their goodness is what they are. Calories and carbs have gotten a bad rap. Show that Mr. Pazlera is out on a $20,000 cash bond. Posted February 27th of 21. Kevin Lee Wood. Colin Gary Teague. All right, I believe that concludes this morning's docket. We will resume at 1:30.
This is my concern.
Yeah, I can't see that. I'll have to make it bigger.
It's just the notice of arraignment says 1:30. That's the one.
Oh, you know what? He might have.
I have no idea. That's just what I'm saying.
Okay.
So if
I'll
we just
wait.
take
I'll
that-
wait.
If we take it under advisement until 1:30, see if it appears. Just so we don't have to do a bunch more extra work and then he shows up and says, I'm supposed to be here.
Well, he's got $20,000 riding on it, so better give him the benefit of the doubt on that. All right, court will take judgment Nyside under advisement for Ullman Pazlera until 1:30. The court finds that the court's notice of setting indicated that setting was at 1:30. All right, court's gonna stand in recess until 1:30.